All right. Hi, welcome back. Attorney Steve Vondran, and welcome to another exciting episode of Litigation Whiteboard. Attorney Steve Vondran here with you. This is general legal information only and not legal advice. This is a trade secret crash course. So if you have a trade secret class, or you're going like, what? I want to know a little bit about it before I get in, or you know what? I have a problem with a disgruntled boss and I need to know real quick about trade secrets. So without further ado, let's head to the Attorney Steve Litigation Whiteboard. Whoa, have that removed. Not sure what that is doing there. Okay, so we are talking about trade secret misappropriation. I'm going to talk about the California law, and it's contained in the Civil Code. And I have up here, marked up here first, IP. Is it IP? Some people say a trade secret is IP. Some people say it's not. I say it is. But anyway, I want to talk to you real quick, and I'm going to give you one concrete example to make this pretty simple for you, so you will know what a trade secret is. If you're at a party and you go, I don't like to talk to lawyers, I don't get it, they talk about trade secrets, it's all so confusing. It's really not. Think about this. I'll give you two examples. Coca-Cola secret recipe, KFC, Kentucky Fried Chicken secret recipe. These are trade secrets. Nobody knows what it is. I have tried so many times. I eat KFC, and usually I love it. Sometimes it's a little too dry, but I always wonder what is it in there? There's something in the batter, or there's like something peppery. I just can't figure it out. But it's a trade secret, okay? It's not a copyright. It's not a patent. The reason it's not a patent is when you patent something, you have to disclose it to the world, and then you get a limited monopoly. Trade secrets can last forever, just like a trademark. If you continue to use your trademark and pay the fees, you can have a unlimited trademark. So trademarks and trade secrets are very cool. I consider them both to be forms of intellectual property. There's no dispute about trademarks. So let's talk about it. Let's say we have the Coke formula, the Coke recipe, okay? And then you have a vice president that works here. We're going to call these bad actors. A vice president that works here decides one day, and he had access, or she had access to the secret sauce, the secret formula, or other secret things, which we'll talk about in a second, the different things that can qualify as a trade secret. But say this VP had the secret sauce, decided, you know what, I can go, I can leave. I don't care if I have a contract. I don't care if I have a non-compete agreement, which we'll talk about in other videos. I don't care if there's a trade secret clause. I don't care if they do an exit interview telling me I better be careful. I don't care. I'm going to go start a competitor company, and I don't care. I'm going to do it. So this is kind of a typical kind of thing with competitors, and as I say, the departing employee. But sometimes it's the opposite. It's the bully or the disgruntled employer who wants to go sue somebody claiming just to harass them. Okay, and we have cases like that, believe me. So cyber attackers can go, but let's talk about trade secrets real quick. What is a trade secret? A trade secret is anything that is not generally known. It's not public knowledge, okay? If it's something's public knowledge, hey, everybody in the industry knows that. I don't care. You can call it a trade secret, but it's not a trade secret if everybody knows it, if everybody's doing it. You can't try to pretend you have a trademark just because you wrote it up in a contract. So it's not generally known, number one. It's valuable. It's independently valuable. And it provides a competitive advantage because it is independently valuable. For example, if you gave somebody the Coca-Cola secret recipe, the secret formula, oh man, can you imagine the value of that? So it's not generally known. It's valuable, provides competitive advantage. How much value that it provides, that can be an open-ended question. And its economic value derives from being secret, okay, from keeping it secret. And finally, the third thing you need if you want to establish that you have a trademark is that and this is the important one, they have reasonable measures to keep it secret. You are taking reasonable steps, and that can be a lot of different things. For example, locking it in a vault, your secret recipe, the formula, locking it in a vault, limiting access on a need-to-know basis or on a need-to-access basis. That can be very important. Contracts, non-disclosures, do not disclose this, or you're going to get sued, or we're going to seek an injunction or damages or liquidated damages. Limiting who gets to use it and access to it. Security cards. cyber security, info security, anything you can do to keep it secret. Because once you lose the secrecy value, if you lose that, your trademark's gone, and now it's open to the world, and the whole thing, your whole business could be, kind of in jeopardy because now it's out there. You didn't take the reasonable steps and measures. These are the 3 steps: training your employees, employee handbooks, manuals, all kinds of things you can do to take the reasonable steps to keep it secret. So here's your 3 things you're looking for. Let me do that for you. Trade secret is not generally known, provides competitive advantage, reasonable measures to keep secret. Now, what kind of things can be trade secretable? Could be any formula, bland device, process. It could be anything. Okay, literally. Could literally be anything that provides an economic benefit, competitive advantage. Business plans, what our company has done or what we're doing next. Our business and marketing plans. Our financials. Our customer list. This is an important one. You spend a lot of time cultivating a customer list. You get it all together. It has value. But these are contentious cases. The customer list, as I mentioned, secret recipe, secret sauce, secret formula, cost data and budgets, things having to do with your finances. How much do you pay for this? How much? Where do you get it from your suppliers? Who are your suppliers? The software that you use, the technology that you use, things that give you competitive advantage can be subject to trademarks. Vendor lists, supplier lists. What do I have here? Non-patentable inventions. So you can have an invention that you say, well, I'm not going to patent it. Let's say we're just going to keep it a trade secret. Could be source code for software. We're just going to keep it a secret. We're not going to. If I do the patent again, it's publicly disclosed, the details. And now everybody knows. I get a monopoly for 20 years. I get a limited monopoly, but after that, it's open to the public. So that's what it is with inventions. We talk software code. I like this one, business fails. What's that? Well, so maybe you're doing research and development, which could also be a trade secret. Things that didn't work. Okay, you say, we tried this, it failed. You could have spent a year on something only to find out that it fails. Well, that's valuable information, like negative information, but it's valuable because you learned what didn't work. You tried this and it didn't work. That could be trade secrets. Supply sources, who are your suppliers? And maybe you're doing competitive analysis and you have lots of information on your competitors. So a lot of things, and this is not an exclusive list, a lot of things can be trade secrets if they're not generally known, have value, reasonable measures. Okay, so there you have it. That's that. Now, let's talk real quick about misappropriation of trade secrets. That's pretty simple. You have somebody that has a duty to keep it secret. They acquire the trade secret by improper means. That can be a lot of different things. Improper means over here, hackers, theft, bribery, espionage. Somebody's inducing social engineering. They're inducing somebody to give up the trade secrets. Could be a lot of things, but basically misappropriation of the trade secrets. You're acquiring a trade secret by improper means. You're using or disclosing. So it could be a discloser. It could be a disclosee. Somebody who knows that it's a trade secret and says, hey, buddy, do you want the plans for the next thing we're building? Yeah. Shh, keep it on the lowdown. It says trade secret and confidential on it, but here you go. So you got to be careful, things like that. But if somebody has knowledge of the trade secret, improper use and disclosure, violating non-disclosure agreements, things like that can be misappropriation. So it's pretty simple. You know you're doing something wrong. You're stealing, okay? You're stealing, and you're stealing, okay? Damages and remedies, what can you seek if there's a lawsuit? Of course, you want to get that injunction to stop any further leaking, any further damage. Your actual losses, if you lost $10 million, seek $10 million. Unjust enrichment, if somebody got something that they shouldn't have gotten, as we call it, ill-gotten gain. So you were unjustly rich, $50 million. It's not your money. Why are you entitled to that? So you got the trade secret and you made $50 million. Well, that's my money. You're unjustly enriched. That's what we love, my favorite phrase. Disgorge ill-gotten gains. Disgorge ill-gotten gains. Reasonable royalties. So maybe you have people that you transfer the technology to, licensing agreements. again, under high security measures to keep secrets, and somebody violates it, well, you can seek reasonable royalty. So that's an interesting remedy that you don't always see. Finally, we have exemplary, and exemplary damages is, for my favorite Attorney Steve students, exemplary damages is damages designed to punish and deter. 2 times exemplary damages where you have willful and malicious conduct. And I'll tell you, in the world of trade secrets, people starting competing companies, you're going to have willful and malicious stuff. So look for that. And of course, you seek your attorney fees when you can. I'm not going to go into it here. I will do a separate on the Federal Trade Secret Act. So we do have state, the CUTSA, California Uniform Trade Secret Act, Defend Trade Secrets Acts, which is based on UTSA and CUTSA, all these great words. But that's it. I mean, you got a general look at trade secrets law. Now you know when you're at a party, here's somebody, hey, it's a trade secret. You should develop a trade secret. If you work internally for a company, you should maybe be looking around and say, is that a trade secret? Maybe we should protect that with our contracts and our measures. Like maybe that's a valuable trade secret. So there are companies and even law firms that come out and help you identify your trademarks, protect your trademarks. We're on the litigation side. I handle disputes. That's what we do. So I hope that's been helpful. I hope you have a great Sunday. If you need more help, you know where to find us on the web at attorneysteve.com. That's attorneysteve.com. The first name in legal services. Thanks for watching. If you like this, boom, hit that like button, subscribe. We're trying to get up to 50,000 subscribers. I got to get moving this year, so I'm working hard at having more videos for you. And the notification bell, you want to get the videos when they come out, okay? Feel free to share this video on your social media networks. I got to run. Take care. Have a great day. Bye now.